Hello, Hoosick Falls. On the eve of what I think could be a defining moment for our village, I am presenting this video as a way of explaining as simply as possible what is going on with this agreement, why so many big names are weighing in on it, what this agreement is, and what it isn't. Recently, a friend of mine told me that she had had a hard time staying on top of this topic because there's just so much going on and it's very hard to understand all of it. So if you are in this boat, this video is for you. There are two main arguments for and against this agreement. One argument is the need for money ASAP. The village has accrued costs, it's budget season right now, and they need to make up the difference. The other argument that we've heard is that the village is giving up its rights. We've heard this argument again and again, in particular from some very high-profile people who have a great deal of experience. Here are a few of them. Dr. Howard Freed urged the board to not sign the latest agreement, quote, in the strongest possible terms. He later said, quote, the agreement is, in my opinion, so very favorable to the polluters and so very unfavorable to the people of Hoosick Falls that, if signed, it may even hold up Hoosick Falls for ridicule as a national example of what not to do. There is no valid reason for the village to give up its legal rights. David Engel, lawyer for the Healthy Hoosick Water, has spent the better part of the past month pointing out the holes in this and the previous agreement, as well as the holes in the village lawyer's fact about the first agreement. Judith Enck, former head of the EPA's Region 2, which covers all of New York State, New Jersey, the Virgin Islands, Puerto Rico, and 8 Indian nations, had this to say about the agreement, quote, as a former environmental regulator, I have never seen a more one-sided and ill-advised legal agreement between a local government and large polluters. And later she said, there is no valid reason for the village to give up its legal rights today. And just yesterday, United States Senator Kirsten Gillibrand, who was a lawyer before she became a U.S. Senator, weighed in, saying, quote, I have very serious concerns that the terms stipulated in this proposal are not in the best interests of the residents of the village of Hoosick Falls. So what does this mean? Signing legal rights away is a pretty big deal. When we as individuals sign a document, we are legally agreeing to the terms within the document, the fine print that we typically never read. Well, this agreement, this document, is the fine print, and every single word is of utmost importance. This is a legal contract that defines the terms of the relationship, what you can and can't do, what you will get out of it, and what you won't. Basically, if the village signs this, it is legally bound to it and all of the terms inside of it. This agreement is 8 pages long. After reading it a couple times and also reading the consent order that is often spoken about, I had a number of concerns about many facets of this agreement. However, I am only a music teacher. I'm not a legal expert. I have no experience with environmental pollution cases. I am not a scientist, and I do not know municipal law inside and out. And that's why I spoke to 5 different lawyers this week. Beside David Engel of Healthy Hoosick Water, the other 4 have between them decades of experience litigating Superfund sites, litigating environmental cases, and representing municipalities and counties. There was even experience working in DEC, and after discussions with them, many of my concerns were confirmed. One specifically said this agreement was a bad idea. One is even well known for his accomplishments in the Ohio Valley and actually gave me permission to mention him. I also spoke with Judith Enck. I've even been in touch with scientists who know about this stuff. So here are my 10 concerns with the agreement. Number 1, signing away our rights. This is the obvious big one, but I'll pass on some points that were communicated to me. The timing of this is very suspect and favors the polluters. We don't even know the full extent of the pollution this early in the game. Many people spoke to the fact the problem was always bigger than people thought. It doesn't make any sense to sign our rights away when we don't even know the full extent of the situation, or in other words, we don't even know what rights we're signing away. Number 2, ambiguity. Things are not clearly defined. For example, and this is important, define municipal water supply. Does it mean the wells? Does it mean the aquifer? Does it mean both? The document does go into lots of detail about the appurtenances, citing wells, pumps, holding tanks, etc., but doesn't actually define municipal water supply. This is an example of an easy loophole that can be taken advantage of by large corporations who are seasoned at handling Superfund sites and have huge groups of lawyers at their disposal. As one lawyer put it, if you are going to give up your rights, those rights better be well defined. Number 3, leaning on the consent order. The consent order is an agreement that was signed by the state and the polluters. It does establish many things and covers the financial cost of certain things, including the setup of the GAC filter. However, it is limited. Also of note, the Village of Hoosick Falls is not listed as a party in the consent order. The parties, as defined by the document, are the state and the polluters. These agreements could be renegotiated and the village would not have a say. Number 4, analysis of the financial part of the settlement. The lack of a thorough analysis of the past, current, and future costs of the situation is alarming. So many people stress that more costs will arise. Some won't be covered in the consent order. This agreement includes terms that would sign away our rights to pursue, quote, any and all claims which the village has or might have in the future against the corporate releases relating in any extent to the presence of PFOA in the village's current municipal water supply and current well configuration and all appurtenances. If costs related to PFOA in the water supply arise later, and we have signed this agreement, then we have no way to seek those costs from the state or the polluters. We end up burdened with the cost with no legal way to get it back. Number 5, the right to seek indemnification. This is the other really major problem with this agreement. Right now, this agreement does not offer any protection to the village. If someone wanted to sue the village for the pollution, they technically could, even though the village didn't cause the pollution. The polluters should have responsibility to provide protection to the village in case the village faces a lawsuit as the polluters caused the pollution. This is called an indemnification clause, and this agreement does not have one. This document states, and I quote, the village reserves its rights, if any, to seek defense, indemnity, contribution, or other recover of costs paid. That is essentially legal fluff. The village also reserves its rights to seek free hamburgers for all its residents. We don't need the right to seek it, we need to secure it now. Number 6, the polluters can sue us. Based on the language, the polluters still reserve their right to sue the village, even though they are releasing their right to sue, quote, relating in any extent to the presence of PFOA in the village's current municipal water supply. It goes on later to say, quote, St. Gobain and Honeywell reserve their right, if any, to seek contribution or other recovery of costs paid, and or for any costs incurred or to be incurred by St. Gobain and or Honeywell in connection with any responses, actions, or damages other than St. Gobain Honeywell covered claims from any part including the village, and nothing herein shall be interpreted as a release or waiver of such claims. Not only does this agreement not protect the village, but it actually allows the polluter to sue the village. Number 7, money. The money cited in this agreement is a pittance compared to big corporations. Superfund sites are well known to be multi-million-dollar operations, like lots and lots of millions. This is such a tiny drop in the bucket for the companies, which is why they would jump at this. As many people I have spoke with pointed out, these are sophisticated companies who know the rules of state and federal Superfund inside and out. They are out to protect their bottom line first and foremost. Just to give you perspective, Honeywell's pollution of Lake Onondaga was estimated by DEC in 2007 to cost $451 million. Number 8, whereas clauses lack specific truths and come off as propaganda. Nearly 2 pages of whereas clauses were added to this document, which, as a reminder, are not legally binding. While they do finally give some clarification of things that were lacking in the first agreement, they are a bit, well, ridiculous. Are we really going to sign a document that states the following? St. Gobain and Honeywell are committed to, quote, protect human health and the environment, provide drinking water that meets all applicable guidelines, rules, and regulations to residents, and protect groundwater in the region in as expedited a manner as possible. Number 9. Incorrect numbers. This legally binding document has an error in the numbering system of sections. Does that affect the integrity of the document? Number 10. Opinion of counsel. There have been many communications released by the village, either summarizing this agreement or defending the first one. What we need is a legal document that addresses these concerns brought up, not a frequently asked questions page. This document can be requested and is called an opinion of counsel. In the words of Healthy Hoosick Water's David Engel, quote, "As you know, on a matter of this significance, it is often appropriate and good practice that the law firm representing a settling party, here the village, will issue an opinion of counsel as to the adequacy of the proposed settlement and its legal sufficiency." Was this requested? Was the village board made aware that this was possible? So, how should we respond? First and foremost, we need to be united in a neighborly way, and we need to present the truth of the situation, not the wrath of our response. We need to communicate honestly with the members of the board. This can be done through letters, through emails, through phone calls, or just seeing if they're available for a conversation. I encourage you to make even just one respectful contact, even just to ask about a point or two before Monday night's meeting. And I also encourage you to come to the meeting on Monday and be present. The window to make your comments known is almost closed. If you want to act, the time is now. Thank you for your time and for considering this.